Hello. In this recording, we begin our conversation about the substantive affirmative defenses of self defense. And then in the next recordings, we'll take up insanity. So, this recording covers self defense. A few introductory comments I want to make. The first, the general common law principle or rule of self defense is that an individual may use physical force only when certain triggering conditions and the necessity of a particular response exist. Said another way, self defense may only be used where there is necessity to act in response to a trigger and in an amount determined by the necessity of the response. So, the second point I want to make is that the vast majority of actual self defense cases involve use of self defense against a possible homicidal force or force involving very serious bodily injury. So, our discussion of self defense will focus on the use of deadly force in response to serious uses of force. It is possible to use self defense in response to a less than homicidal force, aka a non deadly force, and it is possible to use less than deadly force, aka non deadly force, in response. So, for example, if someone simply pushes me, I can defend myself physically, but not with deadly force. However, we will not focus our discussion on those cases. Instead, we will focus on the use of deadly force in response to a homicidal force or force involving very serious bodily injury. Take a look at the first slide, which presents the Peterson case and the basic traditional common law approach to self-defense. Peterson also reveals some more modern majority approaches. So here, the goal is to first methodically unpack the basic rules to determine the elements of the defense, and then determine any limits on the defense, including whether an aggressor may claim the defense, whether there is a duty to run away, to live to fight another day, and whether the ability to claim the defense depends on whether the individual is in public or in his private home. So Peterson, in part one, sets out brief relevant facts, and we'll come back to those at the end of the discussion of the doctrine. Part three discusses the historical basics of the defense, including reference to Blackstone, our vaunted English treatise writer whom we've seen throughout the course of the semester. And in part three, the court reinforces that invocation and scope of the defense are determined by necessity. Self-help, self-preservation that would harm another is permitted in narrow circumstances, in instances where that self-help or self-preservation is necessary. Therefore, keep in mind that as we're walking through these basic elements and the limits, all of the underlying or undergirding theory should be necessity. So the doctrine should relate to necessity, and as we'll see later, the particular facts of the case as applied to the doctrine should reflect necessity. So the basic elements that the court sets out for a claim of self-defense include four, as I identify them. You might identify them differently. It makes no difference to me how you identify them, but you must be sure that you are identifying all of the basic elements. So the four elements, as I take them to be, include first, a threat, actual or apparent, of the use of deadly force against the defender. Second, the threat to the defender must be both unlawful and immediate. Third, the defender must have honestly, meaning in good faith, and reasonably believed he was in imminent peril of death or serious bodily harm. And fourth, the defender must honestly and reasonably believe deadly force was necessary to save himself. All right, so four basic elements. A little bit of interpretation is needed. For example, how does the court define deadly force? Does deadly force only mean force that results in death? The answer is that force or deadly force is that capable of inflicting death or serious bodily harm. The force that's used does not actually have to result in death or serious bodily harm, although, of course, that would be deadly force. In terms of the term or element of an honest belief in imminent peril of death or serious bodily harm, and an honest belief that the response is necessary to save himself, again, by honest, the court means good faith. And then for the reasonableness requirements, that there be a reasonable belief the defender was in imminent peril of death or serious bodily harm, and a reasonable belief that the deadly response is necessary to save himself, we're talking about an objective standard. Okay, so 4 basic elements that you can pull from the case should be fairly straightforward. Let me know if you have questions. So if you turn to the next slide, we're going to consider some possible limits on the defense. Here, we are trying to determine those limits or circumstances in which an individual might be prevented from claiming the defense. There is no legal or factual dispute that the defender can prove all of the elements of self-defense, but nonetheless, we say because of certain limits, we will not allow the benefit of the defense, even though all of the elements could be proven. And so we have here a series of hypos. We're going to work from the top row down to the bottom row and then actually come back to the top row. So if you take a look at the first row, here we're trying to determine whether or not aggressors or provocateurs can claim the defense. So looking at the top row and then moving from your left to your right as you look at the slide, assume that A uses non-deadly force against another B. So for example, A punches B in the nose, and doing so would not result in serious bodily injury to B. At most, B would suffer a bloody nose or maybe a chipped tooth. But as a result of A's punch, a serious fight, a fight to the death on the part of both individuals, A and B, breaks out. And during the fight, both parties believe and in fact need to use homicidal force. Ultimately, A kills B. So the question here is, notwithstanding the fact that we could likely demonstrate, based on the way I've set up the problem, all of the elements for A to claim self-defense, is there a limit on the ability of A to succeed? And the answer is yes, A is not entitled to claim or benefit from self-defense. When a defender provokes a conflict or is an aggressor, he may not claim self-defense. As the court states, when the defendant self-generates the necessity to kill or use deadly force, he cannot benefit from a self-defense claim. He forfeits his right to the claim, assuming it existed. The rationale for the rule is grounded in necessity. The defendant, here A, could have averted the situation and could have averted or avoided the killing. His need to use force was not necessary. From a policy perspective, we don't want to permit or encourage people to start a fight or a confrontation knowing that they can later claim self-defense. All right, so a very strict rule that A, who instigated or started the fight by non-deadly force, a punch, cannot later claim self-defense. One thing to notice here, the court hasn't offered a singular or precise definition of the term aggressor. There are a number of interchangeable standards it sets out: one who provokes the conflict, one who precipitates the altercation, one who is not free from fault, one who incites the fatal attack or encourages the fatal quarrel, someone who commits an affirmative unlawful act. All right, so there are a variety of ways to define or understand this term aggressor, or any of them would be appropriate. Okay, So now take a look at the second row. We are using essentially the same facts, except with a slight modification. So assume that B insults A's mother, and as a result, A throws a punch at B. A fight breaks out to the death. During that fight, both need to use deadly force, both subjectively and objectively. A ends up killing B. Can A claim self-defense? Or instead, can B, who started or precipitated the punch by A with a verbal insult? So the answer here is that A still cannot benefit from a claim of self-defense. So mere words or verbal threats do not constitute provocation or aggression for self-defense purposes. There must be a physical action or threat of physical action. In contemporary times, as with heat of passion, the general proposition is that words alone do not create a right of self-defense. So even if A was motivated or prompted to punch B, which led to the fight, because of an insult, A is still not entitled to the defense. He is still the first aggressor when he threw the punch. And as we saw in the first row, he's not entitled to claim the defense. Okay, so take a look at the third row or the bottom row. And again, we're playing off the factual scenario we've laid out in the previous two hypotheticals. Now, assume that A offers evidence that after he punched B, he turned around and walked away, heading to his car to leave. Then a fight breaks out to the death because B chases him down and begins the fight. Again, during the fight, both objectively and subjectively believe they need to use deadly force, and they are correct in their assessments. A ends up killing B. So now in this scenario, can A claim self-defense? The answer is yes. Although he was the first to instigate by punching B, he regained or restored his right to use self-defense. Let me say that again. Although by punching B, A loses his right to claim self-defense because he's the aggressor, when he turns and walks away, he regains or restores his right to use self-defense. Why is this? By walking away, by turning his back and walking away towards his car to leave, A has communicated an intention to withdraw from the conflict and has attempted in good faith to withdraw. And yet it is B who continues to engage. All right. So what we see here is that an initial aggressor, here A, can regain his forfeited right to self-defense. Why would we allow that? We just determined that we don't allow aggressors to claim self-defense because we want to deter them from wrongdoing or creating situations that could have been avoided, and the need to use force wasn't necessary except for their behavior. So why would we allow one to cover the right to self-defense? Well, the rule does capture a scenario in which a new necessity has arisen. So initially, A generated the scenario that required self-defense, and so he forfeits it. There was no need to claim self-defense or no need for self-defense if he hadn't acted the way he did. But once he has turned and walked away and attempted to withdraw, right, he has eliminated any cause for concern. But now the victim has disproportionately responded, and now the victim has created the need to use self-defense. And so now it is he who becomes the primary concern. And the goal is to discourage the ultimate victim from continuing with the dispute. Said another way, the initial aggressor backed off, and so now he does need to self-defend because now it is B who becomes the aggressor. And then lastly, think about this. It's good policy, right? We want to reward the initial aggressor, here A, who backs off, and we want to discourage the initial victim from maintaining the dispute. Okay, so 3 different scenarios that we've seen so far in these first 3 rows. In the top row, the aggressor, even one who uses non-deadly force, forfeits the right to claim self-defense. In the second row, if A claims that he was provoked into punching B because B insulted A's mother or hurled some other verbal taunt, that is insufficient to allow A to claim self-defense, right? He is still the first aggressor and he still loses his right to claim self-defense. And then in the third row, if A does act as the initial aggressor by punching B, but then immediately communicates an intention to withdraw from the conflict and actually then does attempt to withdraw from the conflict, then he regains his right of self-defense. And B becomes the initial aggressor whom we focus on. Okay, so those are the limits with respect to aggressors and who constitutes an aggressor, and as well the effect of an effort to withdraw. The last exception we want to look at is the so-called castle exception or the duty to retreat. So we're going to go back to the top row, and again we're going to assume those facts as we see them, but we're going to add another fact. All right, so assume that A punched B in the nose. So again, A used non-deadly force on B. At this point, A has the chance to walk away and avoid further confrontation. All right, B does not immediately respond. So the question becomes, after A has punched B in the nose and in that momentary point of no action, does A have to leave or retreat, or can he stay and fight? And the answer is, under traditional common law, he must leave. The duty to retreat requires that he walk away and avoid further confrontation. Under traditional common law, an individual, whether the aggressor or a non-aggressor, cannot claim self-defense if he had the opportunity to retreat safely and avoid using deadly force. So this is the doctrinal enactment of a maxim we're all familiar with: run away and live to fight another day. And again, that makes sense if we consider that the parameters of the rule are bound by necessity. If you can walk away, deadly force is not necessary. So although at traditional common law we imposed this duty to retreat, that duty to retreat is not boundless, even under traditional common law. So one, an individual does not have to retreat where there is no place to retreat to. And this is a fact-based inquiry. An individual does not have to retreat where doing so would put him in more danger. Remember, the rule requires that an individual retreat safely. So if the facts would indicate that there is no safe way to retreat, then we don't impose the duty to retreat requirement. And then lastly, there is the castle doctrine exception. So an individual is not required to retreat. An individual who is a non-aggressor is not required to retreat when confronted in the home. In some places, that also includes curtilage or the surrounding land of the home. All right, so the castle doctrine is a third circumstance in which an individual does not have to retreat. If you are a non-aggressor in your home, you are not required to retreat if you are confronted in the home, or in some jurisdictions that would include the curtilage, the immediately surrounding area of the home. Here in Peterson, DC, Washington, DC, adheres to that strict common law rule. The court does tell you that many jurisdictions in modern times have adopted a different approach to the duty to retreat, which is that a non-aggressor does not have to retreat. If you didn't start it, you may stand your ground and use deadly force if reasonably necessary. Notice it's not an absolute right. You still may not be the aggressor. It is the non-aggressor is not obligated to retreat. Okay, so now that we have an understanding of the basic elements of the defense and the meanings or interpretation of some of the terms, and as well the basic understanding of the limits on the defense, we can think about how to apply those elements and limitations to this particular case. So here there are two issues. One, whether the defendant was the aggressor and therefore not entitled to the defense, and two, whether the defendant had a duty to retreat and therefore was not entitled to the defense. Okay, so you can take a look at the next slide, which sets out these issues. Also, on your left gives you a little sense of maybe what the property or the homes looked like in that area. If you're not familiar with this type of residential setting and row houses and alleys behind the houses, and the long backyards that might exist behind a house, right? This is a picture of it. And there is foliage and trees, which may or may not exist in some places. Okay, so the court determines that the defendant was the aggressor and therefore not entitled to a self-defense claim. So the question I would pose to you is how you would think about analyzing this. What does the court tell us leads to the conclusion that the defendant is the aggressor and hence not entitled to claim self-defense? And think about, why wasn't V, who was initially stealing car parts, why doesn't V become the initial aggressor rather than the defendant? And then finally, you could think about this question of retreat. The court avoids the issue of whether the retreat rule and the Castle Doctrine apply to the defendant because it rules the defendant was not entitled to claim self-defense in the first instance. The defendant is the aggressor. He's not entitled to a self-defense claim, so we don't even need to consider the issue of retreat in the Castle Doctrine. If he's not entitled to self-defense, he's not entitled to a Castle Doctrine instruction or any ruling with respect to the duty to retreat. So one consideration for you is, if you assume that the court concluded the defendant was not the aggressor and he was entitled to claim self-defense, would the Castle Doctrine apply to his case and hence eliminate the duty to retreat? I'm going to leave you to think about both of those questions and the court's reasoning and rationale on your own. Let's talk about it on Twin. All right, so the two issues we can think about and talk about on Twin are, in light of the facts and the law, what is the argument that the defendant was the aggressor and hence forfeited his right to claim self-defense? Relatedly, why wasn't V, who was stealing car parts, initially the aggressor? And then if we assume that the defendant was not the aggressor and he was permitted to claim self-defense, would the Castle Doctrine have applied to his case and eliminated his obligation to retreat? All right, let's work through those on Twin. So the next conversation we're going to have is in relation to the reasonable belief requirement. All right, and in this section, you're presented with two cases, Getz and Wainwright, and those cases present us with both a common law approach and a model penal code approach. And here we're revisiting the recurring problem we've seen throughout the course of the semester, which is, who or what is the nature of the reasonable person? What considerations can or should inform our analysis of reasonableness of a defendant's belief? And here we do so in the self-defense context. So We'll talk first about Getz and then about Rainrow, and then I will present a couple problems for you to consider. So next slide. First, we have the Getz case, which is one of a number of infamous cases we have examined in the course of the semester. We also looked at the Noller case, which is a quite notorious case. We looked at that in connection with depraved heart murder. And next week, when we talk about punishment or sentencing, we'll look at the Dew case, which is another quite notorious case. Getz is a case that I suspect by now many of you have no independent recollection of the case. It is more likely that most of you have heard about it from your parents or the news reports or studies or popular culture. So in this particular slide, on your left, the pictures include at the top the scene after the shooting when the police and paramedics were responding, and then on your left in the bottom, this was the scene in the train car after everything and everyone had been cleared out. In the middle bottom is a picture of one of the victims being carried from the subway train to an ambulance. And then in the top middle is a picture of Getz as he was being arrested. And then on the far right are some news reporting or headlines from newspapers around that time. So again, there's lots of information. You can find out more about the case online if you like. It is fair to say that Getz is a case that troubles many academics and many policymakers and many individuals, although not all, because of the legal and social implications. So the opinion in the text arises out of grand jury proceedings and a pretrial motion to dismiss the indictment and the appeal thereof. So besides the fact that this is a notorious case in public consciousness, this is also a particularly interesting case for us to look at in criminal law, because it is not an opinion arising out of trial issues or the appeal of a verdict. It is an opinion that arises out of challenges to the grand jury proceedings. So a brief aside about the grand jury and prosecutorial discretion, if you're not familiar, if you take a look at the next slide. So the prosecutor is in charge of the grand jury, so to speak. The prosecutor determines which individuals, which cases, and which charges to present to the grand jury, and does so using his or her independent authority. The prosecutor determines which witnesses to call and examine before the grand jury. The prosecutor instructs the grand jurors as to the elements of the crime and the burden. And it's important to know that the standard or burden to return an indictment is probable cause to believe that a crime has been committed and the defendant has committed it. It is not beyond a reasonable doubt. And then finally, the prosecutor has almost absolute unreviewed discretion or accountability for what goes on in the grand jury. There is no defense attorney, for the most part, involved in a grand jury proceeding. All right, in the majority of jurisdictions, there is no defense attorney involvement in a grand jury proceeding. And courts have very limited involvement in grand jury proceedings beyond selecting and swearing in the grand jurors. So, as I mentioned, defendants have little say about what happens before a grand jury. Defendants are not present in a grand jury. Suspects are not present in a grand jury. And actually, oftentimes, they're not even aware that the grand jury is meeting to determine whether or not to return charges. If the defendant is aware and asks to appear and testify, then they do so at their own peril. Just a word of advice: if you are ultimately engaged in criminal defense representation, never let your client testify at a grand jury. Those statements can later be used against your defendant, and defense attorneys have little ability to protect their clients during a grand jury. All right, so it is a very rare circumstance in which you allow a defendant to testify before a grand jury. All right, so that's the general overview or understanding of grand juries and prosecutorial discretion or control over grand juries. The Getz grand jury is notable for two reasons. First, this case was presented to a grand jury in Manhattan, New York, 2 times, which is rare. It is usually the case that the grand jury will return an indictment on all charges requested by the prosecution. There is a saying, and it's reflected on your left of the slide, that the grand jury would indict a ham sandwich if that's what the prosecution wanted. So here, the prosecutor presented the case against Getz to a grand jury, and that grand jury only returned an indictment on the firearms charges. The grand jury declined to return homicide charges. So the prosecutor presented the case a second time. And in that second presentment, the grand jury returned the 10 charges that ultimately were at issue here and on which the defendant was tried. The prosecution was completely within its discretion to present the case more than one time to obtain more charges, and it could do so to the same grand jury or to a different grand jury. That is completely within the government's discretion and authority. So prosecutors can represent cases over and over until they reach the result they want. The second reason this is a notable grand jury process is that here the government anticipated that the defendant was ultimately going to seek to prove self-defense. And so the prosecutor chose to instruct the grand jury on self-defense, allowing the grand jury to make a preliminary determination as to whether or not a self-defense claim would be warranted, and hence no charges would be merited. Why would the prosecutor do that? Why would the prosecutor present evidence potentially supporting a self-defense claim and provide instructions to the grand jurors on a self-defense claim? The prosecutor was under no obligation to do so. The prosecution does not bear any initial burden with respect to the self-defense claim. It's nice from the defendant's perspective that the prosecutor did so, but the prosecutor was not obligated. And there might be multiple reasons why the prosecutor chose to exercise his discretion in this manner. So one, grand juries are designed to act as a barometer for legal sufficiency and as well public sentiment. All right, is there enough evidence to put forth the charge and require a defendant to face those charges? And from the public's perspective, should the case go forward? Another reason may be, well, the prosecutor looks good either way. To those who would seek or want prosecution, the prosecutor has presented the case. To those who critique prosecution or think that Getz shouldn't be prosecuted, if the grand jury did not return an indictment, then the government also looks favorable. Maybe the government believed in the legal strength of the case. All right, it does seem from the facts of the case, as applied to the elements, that there is a pretty strong argument that some portion of the conduct that Getz committed was not legitimately in self-defense. So while some of his behavior might support a self-defense claim, there's a strong argument that others of his behavior in the course of conduct did not. Finally, maybe from the government's or law enforcement's perspective, you want to discourage individuals from taking it upon themselves to engage in crime fighting or be a vigilante. Or maybe you want to discourage untrained individuals from using firearms, or you want to be sure that individuals are not mistaken or unreasonable. Maybe you want respect for the law from everyone. So prosecutors and law enforcement might have a different perspective about this case in comparison to ordinary citizens. All right, so there are many explanations for why the prosecutor may not have wanted to present the case. And a final one could be that the, oh, excuse me. So there are also some explanations for why the prosecutor might not have wanted to present the case or might not have wanted to present the self-defense evidence and doctrine, which is that the prosecutor is an elected local official. And so the prosecutor has to be sensitive to the will of the citizens who elected him. So that might influence the decision about whether or not to present self-defense to the grand jury. Okay, so one final note here. As I mentioned, the case arises out of the grand jury proceedings. You should be aware that most grand jury proceedings are kept confidential and the grand jury deliberates in secret, and any minutes or transcript of the grand jury usually are not reviewed. All right. Sometimes they are, and here they were, but they are often not reviewed by any court official or a prosecutor or a defense attorney. Okay, so a particularly notable case, not just because of the subject, but also for your perspective because of the grand jury process. All right, so next slide here helps us look at the doctrine that was applied in this particular jurisdiction and compare the New York doctrine to the Model Penal Code. So on your left, set out are the elements of a self-defense claim in New York. An individual is permitted to use deadly physical force when he reasonably believes that another person is using or about to use deadly physical force, or reasonably believes that another person is committing or attempting to commit one of certain enumerated offenses, including robbery, and the defendant reasonably believes deadly physical force is necessary to avert a perceived threat. All right, so this is essentially the same standard as we've seen in the Peterson case, except that New York has itemized a number of scenarios in which an individual may be presumptively entitled to use self-defense. So when certain crimes are being committed against the individual, then the belief in the need to use deadly physical force in response is a reasonable belief. But the elements are essentially the same as you would see under a traditional common law approach. Here, the issue arose as to what was the meaning of reasonably believes. A grand juror asked the prosecutor during the grand jury proceedings what was the meaning of that phrase. And the prosecutor instructed that the phrase meant whether the defendant's conduct was that of a reasonable man in the defendant's situation. The defendant countered that the statute actually imposed a subjective standard as contained in Model Penal Code section 3.04. So from the defendant's perspective, his claim was that it only mattered whether the belief in the need to use force was reasonable to the defendant. So what's the difference between the prosecution's and the defense's perspectives? So the prosecutor set up an objective standard, a purely objective standard, and the defense is setting up essentially an subjective standard, that the assessment is whether the belief that he needed to use deadly physical force was reasonable to the defendant. Here, ultimately, the court concludes that the standard is objective. The court does recognize that New York's self-defense statute is modeled on the Model Penal Code. The New York statute does adopt most of the language of the Model Penal Code. However, the legislature inserted one word, reasonably. Thus, the court holds that under New York self-defense law, an objective standard is meant by the phrase reasonably believes. All right, so the Model Penal Code's provision does not include the term reasonably. And so the court here concludes by inserting that term into the statute, the legislature was intending to create an objectively reasonable standard. All right. So, in essence, New York adheres to the common law approach to self defense, although the drafters, the legislators, referenced the model penal code when adopting this provision. All right, so that gets us to this recurring, troubling question: what or who is a reasonable person? So, as you see in the right of the slide, the court sets out some standard for determining reasonableness. It's set forth pretty straightforwardly in the opinion and here on the slide. So we're looking at the background and other relevant characteristics of the defendant, as well as the actual circumstances of the particular incident. And we have also itemized some of those characteristics of the defendant that might be relevant, as well as some of the particularities of the incident that might be relevant. So notice, though, there's a tension between this rule or this standard that the court sets out, that you can look at the background and other relevant characteristics of the defendant, and the objective standard that the court declares, right? Looking at the background and other relevant characteristics of the defendant seems to inject a level of subjectivity. In other words, it's possible that we may be able to consider the defendant's mental or emotional characteristics or other personal characteristics. So we'll have to grapple with that. One thing to think about here, after we understand New York's self-defense statute and that it is essentially a traditional common law approach, and that there is a level of reasonableness, but with some subjectivity involved, is how did the jurors here reach their particular verdict? All right. The notes tell you that the jury, which consisted of 10 whites and 2 African Americans, unanimously voted to acquit Getz on all charges except for the possession of a concealed weapon. So, on your own time, you might consider what reasoning might have led the jury to acquit, right, on all of the homicide charges. And more particularly, you might ask yourself, does that decision seem appropriate with respect to each and all of the victims? Or might there be some way that we say Getz's conduct was legally appropriate, was within the bounds of self-defense for some of the victims, but not all of the victims? Another thing to consider, just if we go back to the grand jury here, is that maybe that first grand jury got it right, and the prosecution should have deferred to that first grand jury, which, if you recall, that first grand jury refused to return any homicide charges, but did return an indictment on the weapons charge. Okay, so you have the facts presented in the opinion. You have some additional facts from the notes following the opinion. On your own, with a friend, try and reconstruct the arguments that the defendant would have put forward in support of its self-defense claim, and try and reconstruct the prosecution's rebuttal arguments. And let's talk on twin. The last problem in this section is the Wainwright case. And here in Wainwright, we continue to explore this question of the reasonable person and the further subjectivization of that reasonable person standard in the context of self-defense. And we do so particularly looking at a female self-defense claimant. So, next slide. In this particular case, the defendant is convicted of second-degree murder and appeals. And on appeal, the defendant claimed that the trial court improperly instructed the jury. At trial, the judge instructed the jury with respect to the formation of the belief in the need to use deadly force to consider only acts and circumstances at or immediately before the killing, and with respect to the reasonable person standard, the trial court set up a purely objective masculine standard. All right, so at trial, the jury was instructed to consider only the acts and circumstances at or immediately before the killing, and In terms of reasonableness, the court set up a purely objective masculine standard. So on appeal, the defendant challenged those instructions, and the appellate court agreed that the instructions were erroneous. Instead, the trial court should have instructed that the need for deadly force was to be evaluated in light of all facts and circumstances known to the defendant, including those known substantially before the killing. So essentially here, the court is in accord with the decision in Getz. With respect to the reasonable person standard, the appellate court concludes that the trial court should have instructed that reasonableness is to be evaluated from the standard of a reasonable person in her, a woman's situation. So this is both an objective and subjective standard that is feminized. The standard with respect to reasonableness differs from Getz's reasonable person standard, right? Getz's reasonable person standard is arguably gender neutral. Here, the court is dictating a feminized or feminine standard of reasonableness. And the court provides a number of explanations for that feminized standard, including a history of discrimination against women, the notion that women are different from men and should have different legal rules, the argument that self-defense rules are male-oriented and unfair or inequitable when applied to women who killed, and so the rules should be gender neutral. We've seen this before in the context of heat of passion. And then the court offers that sex is simply a proxy for other relevant matters, such as size, strength, ability to use force, and experience using force. All right, so sex is simply a proxy for other relevant matters which could be taken into account even if we had a masculine or gender neutral standard. Just FYI, in a subsequent opinion, the court further expanded that by evaluating the evidence from the standpoint of the reasonably prudent person, knowing all the defendant knows and seeing all the defendant sees, our approach to reasonableness incorporates both subjective and objective characteristics. The court further said a reasonable person is expressly variable with the gender of the defendant. All right, so the appellate court here in Wainwright adopts a feminized standard because there is a female defendant. All right, so reasonableness is evaluated from the perspective of a reasonable woman, but as well, the standard is subjective because we consider all the defendant knows and all the defendant sees and the defendant's subjective characteristics. So on your own here, as we did with Getz, try and recreate the arguments that the defendant in Wainwright would have offered as to why her self-defense claim was valid and what would be the prosecution's rebuttal. So a few final points before we take a look at these problems. Takeaways from Getz and Wainwright. We see the subjectivization of the reasonable person standard. We are allowed to examine prior knowledge and experiences of the defendant. And as well, we see the adoption of a gendered standard for evaluating female defendants. And so, as I posited earlier in the semester, if we can consider gender, then why can't we consider other particular characteristics such as race or class or religion or age or sexual orientation? Why do we allow for consideration of gender, and why do we allow for consideration of personal characteristics, but not necessarily broader characteristics? Those are big questions requiring deep analysis, and there are no clear answers. I said that earlier in the semester, and I maintain my position that there are no clear doctrinal answers to the reasonable person standard. There are no clear policy answers to the reasonable person standard. We are all just struggling and grappling with it in various contexts, but it is the case that the standard and those issues arise throughout criminal law. And of course, we can continue to talk about this online. Okay, So the notes after Peterson provide some problems that are good for review, and the notes after Getz and Wainwright provide some food for thought. There are plenty of recent notable cases that we could talk about with respect to self-defense, in particular, self-defense relating to law enforcement officers. But I'm happy to talk about those offline. I do want to turn your attention to two other problems that I've set out for you in this PowerPoint. Both of these problems are real world problems. One, the first slide, Uber mistake, is a little known case arising a few years ago out of New York City. And the second problem, sex trafficked, is a highly known case that was recently determined. So work through these particular problems on your own or with another and post your thoughts on Twin. What would be the defendant's arguments in support of a self-defense claim, and what would be the government's response, right? You have the doctrine. We're looking at a traditional common law approach or maybe a more modern common law approach. As you think about the doctrine, think about social issues as well. To what extent is the doctrine or the decision makers influenced by social norms or biases or race, gender, age, socioeconomic status, power disparities? To what extent are those involved in these cases, or should they be involved in those cases? As we saw in Getz, in Wainwright, these issues are often front and center in self-defense cases. They're difficult conversations, but ones that have to be dealt with in the courtroom and in larger society. Okay, so that is the overview of self-defense. You have basic doctrine under the common law. We're not as interested in the model penal codes approach. That is a minority approach. Not many jurisdictions have adopted that approach. And we have two problems for you to work through, as well as you can try and recreate the arguments that would have been presented in Peterson, in Getz, and in Wainwright. This is an opportunity for you to begin studying and reviewing and preparing for the exam, not just with respect to self-defense, but also with respect to the entire course of the semester. How would you think about constructing your arguments? How can you present them clearly and